Senator Jo Comerford.
Hi, good afternoon, chairs. Thank you so much, Chairs Edwards and Day and members of the Judiciary Committee. I just want to begin by thanking this committee for your painstaking work. We know you have long days in the service of the bills before you, so thank you. I'm pleased to testify today in strong support of S 1045. That's an act protecting personal security. I filed this legislation in partnership with Representatives Sabadosa and Lewis, who filed H 1973. This bill is actually quite simple. It's rooted in a simple idea. Your name should belong to you. In Massachusetts, people change their legal names for many reasons: marriage, divorce, gender affirmation, safety, religious or cultural alignment, or simply because it feels like the right thing to do. But the name change process in our Commonwealth is outdated. Right now, we require petitioners to publish their name change in local newspapers and pay an associated fee, which can reach into the hundreds of dollars. Judges can choose to waive this requirement, but there is no guarantee for petitioners, and practices vary across the state. And I think that's the most important point I need to make today. This is an outdated practice, and they vary. The response to this outdated practice is varied across the state depending on which court you're before. Publication can create serious risks, especially for transgender people, survivors of domestic violence, and others for whom being publicly outed can result in harm. According to the Movement Advancement Project, 27 states in the District of Columbia no longer require name change publication. I suggest through this bill with my colleagues that Massachusetts should join them. Our bill removes the publication requirement but allows judges the discretion to require it in limited public safety-driven circumstances. The bill also ensures that the name change records are secured, segregated from the public record, preventing harmful disclosures due to human error or AI scraping. Segregating these petitions is of the utmost importance, as we've seen in pounded court files that include the names of transgender residents and their contact information appearing on platforms like Trellis, exposing our constituents' private personal information, even as anti-LGBTQ and hate crimes continue to spike across the United States. In short, this bill protects privacy, maintains judicial oversight, and makes name changes safer and more accessible, especially for our most vulnerable residents. We've worked really closely, and here I want to thank especially the trial court administrators with whom we've worked. District attorneys, registers, and other key stakeholders have all weighed in over the past 6 months to revise the bill to address important feedback. The updated language has been provided to the chairs, and it reflects that collaboration. This bill is supported by over 25 organizations statewide, from GLAD Law and the Transgender Political Coalition to Jane Doe and the Office of the Child Advocate. You're going to hear from some of these folks today. So I respectfully urge that the committee report out S 1045 favorably and of course support the bill of my House colleagues. Thank you so much for all you do today and your commitment to the Commonwealth.